Hi, my name's Francesca Kettles. I'm a senior technical caseworker in the Birmingham office, and I'm going to be going over transfers and amendments. So we'll start off with transfers. An application to transfer representation needs to be made directly to the court that's hearing the proceedings. And the form that you should use is the one prescribed by the Criminal Procedure Rule 2015. You can find that linked in our slide pack, and it's also on the Gov website. So you'll send in an application to transfer, that'll go right to the court. The court will then notify us of the decision and we'll issue new representation orders where appropriate. So if we are issuing a new rep order because the court has approved the transfer, the date of that rep order will be when the court agreed to it. So it won't be the date you submitted your request, it will be the date that the court agreed to the transfer. Now, we can only process a transfer where there was legal aid in place to begin with. So if an application was refused or it was rejected at the application stage, there's technically no legal aid in place, so a transfer wouldn't be appropriate in that situation. This also is true for a case where representation was withdrawn. In that case, a transfer isn't appropriate since there is no legal aid in place at the point that you wish to transfer. For this reason, it can be quite important to just double check with the defendant if you are at the point of withdrawing, just to check that that they do actually want to withdraw rather than transfer to a new solicitor, as the procedure for those is a bit different. That's just a little bit on transfers. I'm just going to go over amendments now. So there may be a whole range of amendments that you want to notify us of. It could be client information. So for example, their date of birth might be appearing wrong on the rep order, or their name might need a slight tweak. You can let us know about that. You might want to let us know about adding counsel or adding an offence to an existing rep order. When it comes to adding an offence to an existing rep order, there is a pro forma that we ask to be completed. Again, this is on the Gov website. You can find it there. We ask that it comes through via email to any of the criminal application team email addresses. That'll get picked up by anyone. We ask that it comes through via email rather than a CRM 14, as it's in our guidance to reject it if it comes through as an e-form. So obviously this just helps with everyone's rejection rate. It is just a short application. It's not as long as a full CRM 14. That's another benefit to submitting it as a pro forma. It asks for some details of the defendant, so their name, their date of birth. It will also ask for the MAT number for the original proceedings, and this just means that we can locate the correct case with ease. It also contains a short interest of justice test, which you'll be familiar with from a CRM 14, and that's what the caseworker will be using when they're considering adding this new offence to the rep order for your existing proceedings. The small caveat to all this is you only need to go through this process if the offence is added in the magistrate's court. If the offence is added while the case is in the Crown Court, you don't need to submit the pro forma, you don't need to let us know at that stage. All you'll have to do is, when it gets to the billing stage, inform the billing team that you also wish to claim for that additional offence. And there is a slight change when it comes to adding an offence, depending on whether the offence that you're adding is onto an existing case ID or a new case ID. If it's added to an existing case ID where you already have been granted offences under that case ID, then submit the pro forma. That is the best way to do it. It's the easiest way for you, and we can add those offences. If the new offences that you want to be considered come under a separate case ID, you will need to submit a CRM 14 as they're separate proceedings, so will need to be issued under a separate rep order. So you might just want to double check which category it falls under, as that will affect how you submit it. So that's adding offences. Like I said, another amendment that you might wish to tell us about is adding counsel. The addition of counsel to a rep order is a judicial decision. It's not one that the LAA can authorise. So much like a transfer, you'll have to submit that to the court that's hearing the proceedings for consideration. And again, they'll let us know of the outcome and we'll issue a new rep order where appropriate. But similar to what I was just saying about adding an offence, if counsel is authorised while the case is in the Crown Court, you don't need to let us know about that. We won't issue a new rep order in that case, but you'll be able to bill as normal. That's absolutely fine. So if it gets added in the Magistrates Court, do let us know. If it's in the Crown Court, you don't need to. You'll just be able to bill at the conclusion of the case. So you might also want to contact us about the date of offence on your rep order. This is a known issue. Occasionally the date of offence won't be exactly right on the rep order. It is an issue. We are working on a fix. We don't have a solution at present. All we can do is assure you that you will be able to bill as normal, and it is just something wrong with the system at the minute. You might just want to double check with us if the client you're representing is perhaps a prolific offender, and there's a chance that we may have linked it to the wrong offence. So if the offence date looks like it may relate to a different offence, do get in touch with us and we can check that. Otherwise, it will be absolutely fine when you come to bill. The final aspect that I'm going to talk about when it comes to amendments is the date stamp on an application. So obviously for summary and either way cases, the date stamp that you get on a CRM 14 is retained. So if an application is returned back to you, if it's one of those offence types, you will keep that date stamp, and then regardless of how many times it's returned back to you, that will be the date stamp you have on your rep order. For an indictable or trial-ready in Crown Court case, however, the date stamp updates, and that's because the date stamp is assigned upon the receipt of a fully completed application. So if for whatever reason we reject an application that's one of those case types, when you resubmit, that's when we would recognise it as being fully complete. So the date stamp would be that new submission date. That's the general rule on that. It doesn't take into account the sending hearing guidance that came out fairly recently. It is covered under CLAM 3.4.2, but I'll just run through it and just give a brief overview of what needs to be satisfied in order for us to consider backdating if a case qualifies under these rules. So the whole reason for this guidance is that we recognise there are some circumstances where you may be instructed on the day of the sending hearing, but perhaps won't have all the information needed to submit your application, as we need a fully complete application. So in that instance, what you would need to do is submit your CRM 14 with all the information that you can, leave a note of what is missing and what steps you're going to take to obtain it. Now, when you submit that, incomplete as it is, it will have to be on or before the sending hearing in order for us to be able to potentially backdate later on. So you will submit with what's missing, an explanation of what you're going to do to obtain that missing information, and that will then obviously come into us. We will have to reject because it is an incomplete application, but we do note that you did submit it on or before the sending hearing, and that's a critical part. We'll then send the application back to you for you to fill in the information that you couldn't previously obtain. You'll add that into the e-form, send that back to us, and so long as the above is satisfied and the defendant qualifies for publicly funded legal aid in the Magistrates Court, we will be able to backdate to your initial date of submission, which would be the sending hearing date. Like I said, it's covered in CLAM 3.4.2 with a bit more detail, helpfully how to bypass some of the mandatory fields on the application, but that is the general rule when it comes to backdating a Crown Court case.
Hi everybody, my name is Rebecca Booth. I'm the Senior Technical Lead on the Liverpool Applications team based in Liverpool. I'm just going to be going through withdrawals and changing financial circumstances. So that's slide 15 to 19 in your slide pack. So if you would like to withdraw legal aid, if you send in the pro forma, just saying that you would like to withdraw legal aid, this could be either with or without an undertaking. If it's with an undertaking, we would just need the applicant's name, the MAT ID and confirmation yourself and counsel will not be making a claim against the fund, or confirmation yourself will not be making a claim against the fund and that no counsel was instructed. If there's no undertaking, we can still process the withdrawal, but if there are any contributions on the order, the defendant will still be liable for these contributions up until the point that legal aid is withdrawn. You can submit the undertaking later, and once we receive that undertaking, we can stop any collection activity on the case and, if appropriate, issue a refund for any contributions that have already been paid. If you are a solicitor applying for legal aid after it had already been withdrawn from the first firm, we do need confirmation from the court that they are happy that a second firm is now wanting legal aid, as the regulations state that legal aid must go back to the first firm unless there's a good enough reason. And we do need that from the court as per CLAM 7.2.2. So when you submit a new CRM 14, if you can just put in as an attachment that confirmation from the court that they are happy that you have legal aid in that matter, rather than it going back to the first firm. So I'm just going to go on to slide 18, which is change in financial circumstances. So when you submit a change in financial circumstances, all changes must be evidenced. This could be any changes, either an increase or a decrease in the defendant's income. They could be from their salary to a change in rent, or that they've with a partner or separated from the partner. So any change, if you could submit that in as a change in financial circumstances. So the form looks similar to a CRM 14, but on the first screen, it says this is a change in financial circumstances rather than a new application. So if you just fill that in with all the boxes that are required, ideally, if you could say what the change is, because sometimes it is quite difficult to spot, that would be really helpful. If you say, oh, actually, it's just a change in wages, here's the wage slip, or here's a P45. That would make it easier to process, because they can look like identical, and we don't want to be rejecting it back unnecessarily. So just going to go on a little bit to the 28-day rule on changing financial circumstances. So if you submit a change, and this is evidenced within 28 days of that change occurring, we will backdate that change to when the change occurred. Do the change in financial circumstances to when that change first occurred. If it's out of 28 days, we'll do it from when the form was submitted to us, the change in financial circumstances form. This doesn't apply if the income has increased. We will then do it from when the change occurred. More information on that can be found in CLAM 14.1.